Hi everyone, welcome to the Art of Estate Planning. You're joined today by Caite Brewer, Michele Davis and me, Carrie Payne, on behalf of Tara Lukey. And today we're talking about the way that we document testator reasons for doing things, particularly when it comes to things like excluding beneficiaries or giving beneficiaries an unequal amount of an estate. Before we begin today, I want to acknowledge that I'm hosting this training from the lands of the Turrbal and Yagara people, and I also acknowledge the traditional custodians on the lands of each of which of you are learning, working and living from today. And I pay my respects to elders past, present and emerging, and celebrate their diversity of Aboriginal and Torres Strait Islander people's cultures and their ongoing connections to the lands and waters of Australia. This is an interactive seminar, so please send through your questions. Caite and Michele are totally ready to answer all of those burning questions about this topic. And I know that personally, as an estate planning lawyer, this is a really important topic to discuss because it's something that comes up all the time. And there's not really a lot of guidance out there other than searching through the cases and drilling down into the cases themselves to work out how to do this. Caite and Michele, did you want to tell us a little bit about yourselves each, and then we can talk a little bit about the topic?
Sure, you go first, Michele.
Oh, come on. I was going to say the same thing. Fine. Okay. So, hello everyone, I'm Michele Davis. I am an estate planning lawyer. I've done a bit of all the things, but I find planning is my jam these days. I have a certain specific interest in disentitling conduct, as some of you may or may not know. And as Carrie said, it's one of those things that you kind of trudge through the cases, which, to be honest, I kind of love that part. But moving on. So I'm really excited about this conversation, and I hope you are too. And I'm super keen to hear from anyone in the audience about the questions that you might have. So that's me pretty much. Caite, over to you.
Hi, I'm Caite Brewer, estate barrister, and I have pretty much always been involved in litigation. So apart from doing some planning and some admin for the purposes of being able to tick that box to sit spec a cred, I've pretty much exclusively done estate litigation for about the last 17 years. So happy to answer any questions anybody's got. Carrie, a question for me. I can only see the three of us. How do we know who else is online?
So that was my next question, is I was going to put a post to say, can someone comment and let us know that everyone can hear us? We've got about 20 people online at the moment, so I want to make sure if someone can comment on the video and let us know, that would be great. I've got one love heart, so I'm assuming that means people can hear us.
Oh, you can see more than us, so as long as someone can see something. There we go. We can see people great. Seeing here and see you. Good, excellent.
Thank you, Facebook user.
Yeah.
Yes.
And Tara's here.
Tara's
she's
on.
hiding in the
Yay.
background. People better behave while she's online. So we've got Tara. I hope you've got Rex with you, Tara, so we can start learning about estate planning from a very young age. In terms of today, I mean, we want to keep it quite conversational. So as I said, throw through those questions as they come. I think for me, the main question that I wanted to ask, I mean, there's two that I wanted to check, and certainly that's me being selfish, and I know there'll be some people coming through. But the two questions I want to ask can certainly feed into them separately. The first one is, does it matter if we write down what the intentions are? And then the second is, where the best place is to actually record them. So those are kind of my two main things I wanted to take out from today. And I know certainly that's the two most common questions that come up with a lot of our members in the Art of Estate Planning as well. So if either of you wanted to give us some guidance around how that works and what you're seeing in practice, that would be great.
Carrie, I'm happy to jump in there if you like. I think the second one is the easiest one to answer, so I'll do that first. You never put it in the will. Never, ever put anything about the reasons why somebody is excluding anybody in the will. And the reason for that is really simple, is that the will gets admitted to probate, becomes a public document that any Tom, Dick or Harry can go in and get a copy of from the relevant Supreme Court. So why would you be airing your dirty family laundry, usually that's what it is, in the will? Never make any mention of it. Even the fact that you're excluding somebody, you just don't make any mention of it whatsoever in a will. If you want to document something, you do it as a separate document. Another reason for that is often such statements can be of themselves quite inflammatory. And so you might have an applicant who's been left out who maybe was not going to do anything about it, but then sees a copy of the will and there's some statement in there that they always disagree with, because they never see the statement and say, oh, that's right, that's why I didn't get anything. Mum's right. That never happened. There's always, funnily enough, a second side to the story, sometimes a third or a fourth side. And so them seeing what they believe is an inaccurate and wrong description of something that has occurred is just going to inflame the situation and might encourage a claim where there would otherwise not have been one brought. Whereas if it's done as if reasons are done as a separate document, a stat deck that's signed and kept with the will, the executors can then use their discretion, hopefully on legal advice, as to if and when to disclose those reasons to a potential applicant.
And that's interesting that you say that, because I know exactly what you mean about dirty laundry. I mean, when the situation is already difficult, you've lost someone, everybody's mourning, you don't want to add fuel to that fire, as you've said. Is that the only reason why you wouldn't do that? Because I think that I certainly know some clients that have no problem airing the dirty laundry, so to speak, and have no problem inflaming fires or adding fuel to the fire, so to speak. There's no legal reason why why putting it in a stat deck is better than putting it in a will, for example.
Well, one legal reason could be this: if it's scandalous stuff that goes in there, then that's going to be the sort of thing that might be subject to an application to court to exclude those wills from the admission of that will to probate. So therefore, you automatically go, so if it's anything inflammatory at all that might be considered scandalous, you automatically go from a will that could be admitted to probate in common form and cost, a couple of $1,000s, to something that is potentially a contested application in court that might cost $20,000 or more. So there's another really good reason why you don't put anything like that in the will.
Absolutely.
And on that topic, if I can just weigh in, one of the things is you've got a dispute on your hands or a potential dispute on your hands. That's the last of your worries, is to get the will admitted to probate, get that done so that you can move toward trying to resolve the dispute. So that's the last thing you want to do, is overcomplicate a situation that doesn't have to be that complicated just at that initial stage.
No, that's actually really great feedback.
Remember, of course, the solicitor's job is to advise the clients about this. If they instruct you otherwise, well,
exactly.
A solicitor shouldn't just sit back and go, oh, well, if that's what they want to do, that's what they want to do. I think they should actually try and talk them out of it and tell them why it's a bad idea.
Exactly.
Yeah.
And that's the perfect thing about these sort of seminars. Yeah. If that's the lawful, competent instruction that you get from your client, that's the thing. But as you say, Kate, you've got to advise them. You've got to explain why it's not preferable that you do that, and so they can make a proper informed decision. At the end of the day, if that's what they want to do, knowing all of your advice is on board, it makes it a bit of a tough conversation, but and that is why these sorts of conversations and these sorts of platforms are really good, because you can kind of flesh out, okay, well, if you want to do that, going back to what Kate said at that seminar I went on to one day, these are the couple of reasons you might not want to do that, and then go from there.
I think what our goal is really, as you said, to counsel people into what decisions are going to have effects that they might not think about, and obviously we have to draft a will that the client actually is comfortable with. So yeah, you're absolutely right. If a client still wants it in there and wants to burn the house down, then sometimes that's something that you can't necessarily stop, and all we can do is advise them of the reasons why that might not be appropriate.
And I think the other thing to remember here on that topic, Carrie, is the fact that there's a lot of emotion attached to these sort of conversations as well. And I think as a practitioner, it's really easy to form your own opinion, whether you should or not. We're human beings at the end of the day. So sometimes we can feel, oh, maybe that's really not the right way to go. And sometimes that can come through in the way that we give that advice or express that advice. And I think we have to be cautious to say, I'm not saying if it's right or wrong. That's not a matter for me. From a legal standpoint, I am duty bound to explain these are the reasons why you might not want to put that stuff in the will. My job is to give you the advice. You make the decision, but you need to know both sides of the equation. Otherwise, I'm not doing my job properly. To encourage them to say, I'm not saying that you shouldn't say it. I'm not saying that it's wrong to say it or any of those things, because people can feel really judged as well. And this is a personal conversation in a planning environment. This is as bold and broad as you get, but it's just a really uncomfortable conversation for some people. So anything you can help to appease them, and not appease them, but just getting that barrier down, or that defensiveness that might apply when you're saying you shouldn't put that stuff in the will, just to explain to them why you're cautioning against taking that approach, or why you might want to look at it a different way. I think that goes a long way to having that continual rapport with the client too.
I think that's really relevant. I've learned a statement when I was much younger, that seek first to understand, then be understood. We can say these things about what the legal position is, but if we get to the root of why the client's doing that or saying that, sometimes that helps us give more appropriate advice, or find a way to communicate the advice in a way that makes sense for them. And as you said, it's particularly emotional, so you've got to tread on that area quite delicately.
Yeah, and you're having a conversation that's a couple of hours potentially, versus the history of the top content of the conversation. So there's lots of baggage attached to that conversation. So the communication skills in this space, I think, need to be absolutely top notch to try and navigate those really difficult situations. Because when it comes to a litigation perspective, and Kate, weigh in at any moment, that will impact what ultimately gets written down if it is put in the form of an affidavit or a static or something like that. That it's all one big conversation that happens, even that planning stage. You might consult with Kate and say, Kate, I've got a planning client. They want to do this. We need your help to craft something appropriate. So if the dispute arises, we've got some insight from a litigious perspective about how best to reflect what we're working with.
I would say to them, I would say to you guys, to say to the client who wants to put it into the will, because at this stage we're just talking about where to record if you're going to record. We're not talking about the wiseness or otherwise of recording. So assuming you are recording reasons and a client adamantly wants to put it into a will, point out to them, in Queensland we have section 92 of the Evidence Act. I'm sure there's equivalents in every other state that says if there is if a person is deceased and there is a written statement by them of otherwise admissible evidence, then that is admissible as evidence of the truth of, under section 92 of the Evidence Act. That statement is admissible as evidence of the truth of it. So if you sell it to them on the basis that if we put it in a separate document called a statutory declaration, that document will be admissible in court as evidence of the things that you say in it, that might make them a little bit more persuasive. Whereas even though, technically speaking, a statement that they put in the will and then sign themselves is probably also a statement under section 92 of the Evidence Act or the equivalents. But they don't know that. And you can sort of sell it to them as, you put it in this statement, and then this particular statement is admissible in evidence and of the truth of what's put into it. It might be a bit persuasive.
That's a really good point, actually.
To follow your advice.
It doesn't matter where it's put in, because it's still both admissible, whether it's in the will or not in the will. It's still admissible evidence. Is that sort of where you're going there?
Put your focus on putting in a stat deck and keeping it separate.
Calling it a statement. Yeah. My side note is, a statement that they write in the will is possibly also a statement under section 92 that may also be admissible. But
why muddy the waters if you can clean it up? And coming back to the point before, Kate. Go on. Sorry.
No, I was just saying, I'm just suggesting that, that's something that you can tell the clients as to why it's a good idea. Keep it separate, and then that of itself is, admissible. If you focus on that being admissible to the court as evidence of what they say in it, it might just kind of take their focus away from wanting to try to put it in the will.
Yeah, and more uncomplicated way of making it admissible, rather than trying to argue the whole two-statement business and all that, which is likely to be accurate anyway. But I suppose back to Carrie's point about putting it in the will, I think, actually no, it might have been Kate, sorry, your point about putting it in the will, it kind of highlights, hey, this is why I might make a contest on the will, because this is in the will, and I want to have my day in court because I want to say how it really went down, they say, and I've seen that happen with wills. When I was doing dispute work, the will would say a statement, and the client would come to me, family provision applicant, for example, and say, that's so untrue, and I want to make sure everyone knows it. And that's why they bring a claim. And it was all because it was in the will, and that's just something that you can avoid. And it might push them past the point of just getting to mediation and trying to resolve it as cost effectively as possible and time effectively. But no, they want their day in court, literally. So it's little things like that.
You can potentially avoid it because a lot of these cases, there's just going to be claims brought anyway. So it's probably not going to make too much difference.
I'm an optimist, Kate. You know this.
Yeah. I'm just saying, no,
you're right.
Potentially might avoid.
It doesn't always work. I completely agree with you. But that's just it. Was putting it out there as an option, and people. It doesn't always work, but you never know until you try, I suppose.
My new statement for myself, Michele, is I have a pessimistic mind of a lawyer, but I have a very optimistic heart. So
I like that. Yeah. Well, I think you're trained to be a pessimist as a lawyer. I'm pretty sure that was like the underlying undergrad sort of studies was pessimism.
101.
Yeah. But at the same time, it's a conflicting situation, isn't it? You're an optimist at heart, but then you're a lawyer, so you naturally have to be a pessimist because you're always risk assessing. Where can it all go wrong? Oh dear.
Kate, can I throw a question at both of you, and feel free to say I'd have to look at that a little bit closer because I know this might be something that you haven't looked at recently. But when you said that the section 92 of the Evidence Act, and you can add something like a stat deck into evidence for that sort of application, is that something that an executor is required to give up, or a lawyer is required to give up, or can they give it up at their discretion only?
So can I divide that into pre-proceedings having been commenced and just so no proceedings on foot, and it's just post-death. So completely at the executor's discretion. They don't have to provide it pre any proceedings being on foot, and they can choose to or not. And a sensible executor may choose to withhold something that is just clearly going to be inflammatory and has clearly got misapprehensions of facts in them and all of that sort of thing. My experience generally tends to be that the deceased person chooses an executor who's going to share their views, usually in that way. So often you're not going to have a nonsensical testator with a very sensible executor. Doesn't usually happen, but the executor could, or the executor might be somebody who will listen to advice from their lawyers a bit better and might choose not to share that. Alternatively, it might be that the statement could be of some use, but it can be determined later on. Did somebody just get cut off there? Oh no, something's just come up on my screen, that's all. Secondly, if proceedings are on foot, then it is an executor's duty to put everything before the court that is relevant to the determination of the claim. And so at that point, depending upon what is said in this statement and the truth and veracity of it, etc., it might be that the executor is obliged to disclose that and put it before the court at the post-proceeding stage, but that would depend upon the nature of what was said in it, what those reasons are, whether they're, clearly sort of made up and not based in fact, etc. And that would have to be taken on a case-by-case basis, but probably in theory, once the proceedings are commenced, it might be something that could be compelled and an executor is obliged to give to the other parties in the court. So, I just wonder whether there's a comment from, the first comment from a Facebook user, a 1208 comment. I'm not sure who else can see that, whether it's just the three of us.
Yeah, no, we can see it.
Can everybody else see it, or should I sort of summarize what the question says?
I think summarize it just in case for those people that maybe it might be vision impaired, and then
So someone says, these cases do my head in as an old-fashioned lawyer. The fact that my client's file can be demanded from the court just does my head in. Why can't they have an honest discussion with their lawyer and get full and frank advice? So I guess my question is there another area of law that does this, where you can apparently fairly easily demand a lawyer's file? Is there a corollary that I can draw here to another area of law to look at and think through this point? And then we've got a FR, part of a word, and ... So I think we're not seeing the whole question.
Or something. Yeah, that's what I'm
but
seeing
I think
too.
We've got the gist of it. So first of all, it's not easy really to get it. I wouldn't say it's easy to get. It's not particularly easy to get. If you want to force it, you might need to bring an application to court, and a lot of people are reluctant to do that. So it's not really that easy to do. But why can't they have an honest discussion with their lawyer and get full and frank advice? Well, they can. You don't have to document everything that they say to you. You could have a discussion with them about whether or not you should document what is being discussed, because you might say to them, look, what we're discussing here now is something that could potentially end up before a court. Do you want me to keep a proper record of what we're talking about, or would you like to have an off the record discussion? So you don't have to.
Yeah, that's hard though, Kate.
All of that. Well, because you're going to say from the perspective of risk management for a solicitor that would be a really bad idea to not document that. But why would the solicitor not just make a note that says along the lines of discussed family provision risk, and particularly with respect to applicant, ABC, client did not want advice recorded, something like that.
That does my head in. The concept is my brain's going to explode.
What could ever come back to this against the solicitor?
Well, the thing
is,
what
could ever come back against the solicitor if that was the case?
The content of the conversation might be relevant. And the thing is, the hard thing is you won't know. The solicitor might not recall the detail because time have passed, passage of time, all that kind of jazz. But one thing I can't help but think of when you were talking and reading that particular question out as well, and then talking about the record keeping, is that whole question of whether you are required to hand it over at all in the first place. Is it a document that is owned by the client? Did they pay for the content of the file note? All those sorts of conversations in your brain as well. If it's something that, and maybe that's the thing you have to look at, is it a document that you produced on the client time and the client paid for it, therefore it's the client's document? To what extent that information can be redacted in any subpoena to provide that information, and that may be a question that you can probably talk to. But I think I'm very cognizant in my experience that every solicitor is different in terms of how they record and the detail that they record in a file note. I think that it might be sufficient, and it's always hindsight's going to be perfect in this regard, but it might be sufficient to say what you're suggesting and say, talked about family provision, address the issues of, applicant conduct, or those sort of more generic conversations at least are pinpointed, but not the detail. And maybe that's something you advise that the detail goes into another statement or something if it's relevant for a conduct issue that might get brought up later in the litigation. So I think it depends. I think it would take a fair amount of, and appropriately, fair amount of brain power to consider exactly what you should record to ensure that you do discharge your obligations correctly. You have the relevant information in your file note, so you are covering your butt pretty much. Can
I make a distinction here between, because I know you talked about the concept of whether the file note belongs to the solicitor or the client. In my view, that is irrelevant to when a file has to be produced for either a solemn form proceeding, which is, we see that
there is a distinction.
solicitor files being produced much more in solemn form proceedings than family provision applications. It's pretty rare to see a solicitor's file note ever disclosed in family provision application. I've seen it 2 or 3 times maybe in hundreds
and
it's interesting
to say that, Kate, because a lot of people think that they are pretty open about it, and you see it come into family provision one way or another. So the fact that you say you don't see it very often is quite different to, I think, from my perspective, what estate planning solicitors tend to see, because people
they are in all the time, though, in solemn form proceedings. So where you've got a family provision risk, you've also got a solemn form proceeding risk in a lot of those cases anyway. So I'm saying the risk is much higher that the solicitor's file notes will end up before the court in a solemn form proceeding than a family provision application, but it can also be relevant in a family provision application. What I was going to say about the distinction between whether you own the file note or the client, that's relevant for when a client comes to you and says, please, can I have my file? You take out anything that's your document, you give them their documents. And then there can be a dispute about whether a solicitor's file note is the client's document or yours. When a solicitor's file is relevant to a court proceeding, the whole file is disclosable. It doesn't matter whether a file note belongs to the solicitor or the client. The entire file, the whole lot, including the cover, including any notes that are made on it, including your time recording records, everything is relevant and disclosable when a file becomes disclosed in a court proceeding. So it doesn't matter whether it's your file note or the document belongs to the client.
And someone said something about that here, Kate, as well, saying that they've personally experienced having the court demand their file. So that's in practice.
Is there another area of law where this happens? Well, because my practice has been specialized for a long time, my specialty outside of this area isn't that great anymore. But somewhere where solicitors' files get produced commonly is equitable actions to overturn transactions that are made pre-death. That's the first thing you need in that is the solicitor's file, because the defense usually is the person did this, on estate planning advice and for the purposes of blah, 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 blah. The solicitor's file is always relevant and disclosable in those circumstances. So that's another area of law, although kind of related to this area of law. So possibly not the kind of answer that the person who asked that question was after.
Well, maybe negligence might be another area potentially, like a professional negligence claim or something like that might be another area that do that happen.
Ethical issues and complaints.
Someone's even said family law in the comments as well. So
there you go.
I think as a solicitor, you have got to assume that at some point, and everything you are writing down might end up before a court. I always say to junior solicitors, whenever you write correspondence, assume that a judge is going to be reading it.
Yeah, absolutely. I've said that from day dot for the same.
Large majority of solicitors don't do that.
Only write in an email what you want to go into a court. Someone's actually said something here which related back to something you said before, Kate. They've said, as an officer of the court, can you promise that something is actually off the record? Because they feel like the answer is no. So I think the answer to that is no. I don't think the answer is no. The answer to that is no. If a solicitor on the other side says to you, can we have an off-the-record conversation? You can't agree to that because your obligation is to the client. And so if something comes to your knowledge through that other solicitor, there is no such thing as off the record. Between practitioners, there can be without prejudice conversations. That's completely different to off the record. So if somebody says to you, can we have an off the record conversation? You should say, well, hang on, can I clarify what you mean? Do you mean without prejudice, which means this conversation can't be admitted to court and it can't be relied upon because we're going to potentially be talking on a basis where there might be some admissions made, etc., and talking about settlement. But off the record, I can't make it off the record, and because if you tell me something that's relevant for me to tell my client, I have to tell my client. That's my obligation. What about if it's the client saying, you're like you said before, Kate, that if you say to the client, we can turn the record off for what you want to tell me about the background here, is that something you can do? Or I think that's what the person's asking. It's not so much between practitioners, but between you and your client.
Okay, so I see. So I'm rereading that question now with that in mind. As an officer of the court, can I promise that something is off the record? I feel like the answer is no. Oh, so can you say to the client, if the client says this off the record, well, you can say, I won't make a note of it, but if I'm compelled to give evidence in court and asked about it, then I have to answer truthfully about it. So that is correct, that the answer is no. But you don't have to make a written record of it. And frankly, who's going to remember that in a year's time?
I was just going to say, I think
it might be
people
something
are
that
severely
you do remember.
upgrading my memory skills in that conversation, because that'd be intensely difficult.
I mean, I don't remember things I said to clients yesterday in conference, so you know.
I don't remember what I had for breakfast. I completely and I think in that, on that topic, if I can weigh in from a planning practitioner's perspective, I think what's really important here is the way that you explain to the client and just help them understand what records you do keep in the conversation that you're having, and the fact that it is confidential. It's privileged. Most of it is professionally privileged information too. It's not something that you're going to go and fly around the back, after you leave the consult room and talk about it with everyone. It's not that kind of content. It's for a particular purpose. It's a confidential conversation. And I think in that whole, can we have this off the record conversation, or those questions, where are they coming from? Why? And trying to understand whether it is truly something they don't want any written record of for some reason, or if it's just that they think that they have this misunderstanding of confidentiality or something like that, and just appreciating the differences between those things. But I mean, I think, again, it comes back to, what kind of practitioner are you? Are you a very comprehensive file noter? That's me, because that's just me, and there's lots of different ways you can approach it. But I also look at it from a perspective of, if I'm going to be called to give evidence on this matter later, what information do I need to have recorded in there, just to be able to bring myself to remember that particular consultation too? What other aspects are relevant? It's like in a questionable capacity type of matter, you're going to document things that are slightly different potentially to that of one that's a conduct issue in a family provision risk conversation. So I think it just,
exactly,
you have
because
to be
flexible. We are. That's right. We're having this conversation in the context of the latter, what Michele just said, the conduct in a family provision application. So if we're talking about having the conversation with the testator about why they're cutting out a child, for example, and you sort of having a listen without writing everything down there for the purpose of deciding whether or not you document this, or where, and how, and if so, etc. It's very different to you documenting your investigations that you're making and the questions that you're asking to determine whether or not somebody has capacity to make a will. That is not your determination to make. Your determination is, can I get coherent instructions here to make a will? And it's the court's job to determine later if the person had capacity. Your job is to record everything that you possibly can, so that determination can be made later. So because you're not possibly in a position to know whether or not what they're telling you is truthful, so you're not making an assessment of capacity, you're taking down the evidence for the future determination of capacity.
And on the conduct aspect, the kinds of things you're recording might be the kinds of questions you ask, because as we all know, with emotive situations, they can be coloured in certain ways. And as you have that conversation with the client, you might be testing what they're telling you to be able to really understand whether you're not saying you don't believe them, but you're just trying to really test what information you're gathering from them, because you might uncover that perhaps that's not quite exactly the way they described it earlier, but that may then impact the advice that you give. And that's where those questions may be really relevant. If they're going to falter in front of you about the story that they're telling about conduct, what are the chances of that happening later in a litigation matter? And that might then give you cause to adjust the way that you present your advice to them about the amount of information that they're going to need to give if it ends up in a courtroom, and that's the value as a practitioner. That's the value that you add. Yes, it's an uncomfortable conversation, but it's absolutely necessary to put them in a position where they're making a fully informed decision about what they're doing, not only in their will, but potentially what other statement they might then put in place to accompany that situation if that dispute arose. Does that make sense?
Yeah, yep. And there's another comment that's been made by somebody that says, yes, I've seen a few times largely where a party has often stupidly thrown away their client solicitor confidentiality with the previous solicitor, usually have seen it out of time, family law, property matters. You're talking about waiver of privilege there, because people will swear an affidavit, because it happens in out of time FPA applications as well. because they say, I went and saw a solicitor on such and such, but they told me that I didn't have a claim. Go, okay, well, thank you very much. That file is now disclosable because you've just waived privilege over it, because the client is using the advice given by the solicitor and asserting that as part of their case and the reason why they did or didn't do something. So that amounts to them waiving privilege over the file. But that is a little, and so that's relatively common too, but that's kind of the client's conduct that brings that about. But it's another example where commonly files end up before courts, and often then that is actually disputed and you've got to get a court order to get that file disclosed. But I think that's quite different to the sort of situation that we were talking about earlier with in whether a solicitor's file will or does become relevant in a family provision application.
But I wanted to maybe switch the conversation now to that first question I sort of said at the start of the meeting. So we've talked a lot about the second question about how you document, and certainly
well, the one that I said was the simple that was the simple answer.
I'm ready for it, because I tell you what, there might be some people that say no. I'm certainly ready for the comments. What are the reasons you do or don't document their reasons, and to what extent do you document them as well? Like, do you go into the full history of the family? What things does a court want to see to make sure that the person has obviously considered these other people and the reason they're not doing things or doing certain things?
Michele, did you want to touch on why you might do it?
I was actually thinking, you and I are so alike sometimes. I was thinking exactly that. I will, yeah, happy to. So the reason you would want to document it is because the client really bloody wants to. That might be one thing. Now, that doesn't mean that you throw everything to the wall and see what sticks kind of situation, but that's another conversation. But yeah, if the client really, really wants to, I think at the end of the day, lawful competent instructions, that's what they want to do with all the advice given, etc., then that's what we do. And in terms, my 2 cents in terms of what you do document, I think that it needs to reflect the reasons why the document's necessary in the first place. Why are we disinheriting or reducing provision or whatever it might be? What's the heart of the situation there? And what is the court going to need to understand about that situation or situations or decades, etc., whatever might be the situation we're dealing with? What information is going to be, what's relevant to that reason? What are the reasons? How many reasons are there? And then the detail is more of a litigation question, which I'm going to let Caite talk about, I think, from here.
I'll start off with saying I have never been involved in a case where the reasons left by a testator have ever helped the defence of a claim, and every single time I've had reasons in a case given, they have helped the applicant without exception. I'm waiting on a judgment at the moment where I was for the estate, for the executor of the estate, and there's 2 statutory declarations signed, great detail, by the mother, the deceased, as to why she was disinheriting a daughter. After a lengthy trial, it's quite obvious that mum didn't even write the stat decs. The daughter who she was in
giving more to.
The other daughter was clearly the author of these statutory declarations and not mum. And the judge will, that'll be found as a fact by a judge. And when that judgment comes down, that's going to be a very, very, very good example of exactly what I just said, that those reasons never help the defence of a case, and they always help an applicant.
On that topic, I'm just going to go for it. Sorry. When it comes to those statements, I do not think you should stop making them, notwithstanding what Caite's just said. And I think this is the typical litigator planner conversation here. And Caite, we've had this conversation so many times. And look, all of us have, because there's obviously schools of thought, depending on what you've seen and been exposed to. And I think, yes, they always help the applicant, but I think context is everything. It gives a voice to someone who's not able to have a voice. Yes, it can be a shopping list of what to tick off and disprove, etc. I fully appreciate that. But I'm also, this is the optimist in me, I'm also keen to see how the law develops in this space. And the more cases we have, sadly, that's obviously how it develops. But there could be a change in attitude as the years go on about how those reasons get considered. But if the reasons don't exist because we're afraid that they'll be helped for the applicant will get the help out of it, then we're not going to see that kind of thing. So that's probably a bigger picture thought process, but it's just something that sits in the back of my mind that in my experience with planning, I've had elderly folks, particularly elderly folks, sadly, that have been subject to abuse, and their perpetrator is their family member who is entitled to bring an application, an eligible applicant. And they'll say to me, Michele, I want to leave them out, but I know that it's going to be an absolute shit fight. What do I do? And of course, you give all the advice, all the options, etc. And it might be all they can do is to leave a statement that gives them some semblance of comfort that they've had their say in what's ultimately happened. And it might be the only thing they can do, because it might be through a threat of not seeing the grandchildren that they, leave, or they deal with the abuse in their lifetimes. The way that they leave their will might be the only way they can respond to the abuse that's been perpetrated against them. And so these sorts of things always play in my mind as conduct issues, and that statement might be all that there will ever be as their way to defend themselves against the conduct that they've had to experience during their lifetime. So yes, they help the applicant, but I'd hazard against people not using them just because of that fear, if that makes sense.
No, I agree with you, and I'm not saying don't do it, don't document them.
Oh no, I know. I couldn't help it.
I've never seen it be helpful. But I've also, and I've said this in the podcast that Michele and I did about a year ago on this topic, it's very, very rare to ever see such reasons done in a way that has clearly been settled by somebody who knows what the rules of evidence are, so that they're actually going to be admissible and able to be relied upon for any basis. I think I've maybe seen that once or twice. A lot of the time solicitors say, yeah, sure, if you want to document your reasons for a document, write it all down on a piece of paper and we'll keep it with the will. And so then you get the ramblings of often somebody who's not particularly
articulate or something.
Or just, they're clearly their sense of reality is a little bit different. And
well, it's always biased. It's always someone's story. As you said right at the beginning, Kate, there's always another side. And you're never going to know. As a planning practitioner, you will never know the other side. So you're just empowering your client to do what they can, reflecting their wishes to document something.
Absolutely. And if they are crazy and it comes across as they're crazy, well, then the judge will find that they're crazy. So that might just be the facts. So that's always going to be the situation.
And I think as a planning practitioner, we've got to remind ourselves that these difficulties, these challenges that people are coming to you with, they existed before they came to you. So you do what you can to help them, address it in the context of the advice they're getting from you. Don't get dragged into it. Just they existed beforehand. It's just trying to help them document it for the purposes of what they're engaging you for as well. And I think that's important to remember, because there's some really heavy stuff that gets talked about in those kind of conversations.
Yeah, because back to the very beginning of this part of the question, it was, why would you do it? The reason that you would do it is because it's a relevant factor for the court to take into account on a family provision application what the testator's reasons were. Yeah. So the testator's
set out in the legislation. Yep, character and conduct of the applicant. Exactly.
So the testator's reasons for doing something are a relevant factor for the court to take into account. It's more about how those reasons are documented and to what use they will ever be able to be in litigation, depending upon how they are documented at the time. And telling a client to just go and document them themselves is really, I think, the worst possible thing that a solicitor could do. If it's that important to a client, they really want their views to be heard, tell them that they should be getting that settled by at least a litigation solicitor who knows the rules of evidence, if not counsel.
And that's another thing. There's no reason
it's in admissible format.
Exactly. There's no reason you cannot engage counsel to support the efficacy of that document for the future. Absolutely no reason, because that's exactly right. The evidence issue. I mean, how many I've seen of these statements that are written by Joe Blow and got all the stuff in there. And in fact, there's a comment in the comment section at the moment. Always make my client write it. I get them to send it to me, then I make some comments. It's in their writing, their handwriting, which requires them to make it short, that kind of thing. I think there's real value, not just from a practitioner's perspective, but also from the client's perspective, to be able to get that out of that, their system, so to speak. Because yes, it's for that purpose, but there can be some really good, valuable, just human stuff to get out of that too, because this is a personal conversation that you're having with your client. So sometimes they need to get it out, and that might be enough for them to get it out. It might not be completely at all relevant to what you need from them, but they've got it out, which means you can move to the next part of what you've got to do that's relevant for the documenting side of things. And I just think that's a lot of value in that.
I wonder if a lawyer's hourly rate is cheaper than therapy, guys, because sometimes I think you're absolutely right that sometimes just, doing that spew on paper of all the emotions is very cathartic for a lot of people. Having been involved in a few situations where there's been very cases of very much disentitling conduct, Michele. And as you said, sometimes just it's not necessarily about how it will play out in court. It's the client's opportunity to just get it off their chest.
And can I also, on that topic, I encourage clients to, talk about the elephant in the room and actually try to talk through these sorts of wishes that they have. At the end of the day, it's a matter for them, but the wishes that they have with their family, to explain if they need to, or just, give them the insight that they might need to understand the way that they've made their will for X, Y, and Z reasons. I like to think, maybe it's the optimist, maybe I'm just naive, I don't know, but I like to think that may deal proactively with the risk of litigation, because they've had the opportunity to have that conversation, and the applicant that might be left smaller amount than their siblings or something like that knows it's coming. Okay, yes, it might fuel them, I don't know, but that's a risk that you take. And these are conversations you might have with your client, mind you. That's a risk that you take, but it might also open up a conversation that should have been had 10 years ago, and that could very well overcome things, stop them before they even start. But, it's just, you can't know until you try, really.
I actually think that's a really...
Sorry, Kate.
No, you finish.
I was just going to say, because you don't know how relevant that conversation might be for the evidentiary aspect of their family provision later. They had, they understood this is all that sort of stuff. I don't know. Again, that's an evidence question, but nonetheless, I just think these conversations, they can't just fall on deaf ears. You know what I mean? Like in that context.
Yeah, but what you said, so not so much in the context of reasons for excluding people, etc., but just what you said there about the encouraging people to go and have conversations with their family members about what they're doing with their estate. I am a big believer in, I think half of estate litigation would go away if everybody discussed what they had done or what they were doing with their family members at the time they do it, or the whole time they do it. And I've just bought a house with a partner. We've both got children from previous marriages, so we're about to move.
You need your estate planning done?
Start the Section 5 AA countdown of the 2 years de facto, although arguably it's already started when we signed the contract for the house, or even earlier. But
what a lawyer, Kate.
Honestly.
But I've always been a big believer in it. That if you discuss, I have already done, and you will, Michele, you'll be happy to know, I've already done it, and I've already told both my children and my partner. Well, my partner's got a copy of it, and my children, I've told them what's in it, because I don't want there to be any surprises. And a lot of the time, acting for applicants, it's the shock factor and it's the hurt factor of not, well, why didn't they tell me if that's what they wanted to do? And I see it in particular where you're favouring one child over another, or in second marriages, first second marriages, children of or prior relationships, where it's just not discussed and nobody ever discusses it. But as my children tell me all the time, apparently that's the norm, is to not discuss it. Most people don't discuss wills and those sorts of things at the dinner table.
Yeah. But that's so right. Like, it's the shock factor that I have found in family provision applicants, initial consultation. They're just like, I'm so surprised. This is not what we thought. We always understood this, and you know what? It's that hurt. You can see it. If you can read people, you can see the hurt behind, and all they want is an answer to their question, why? And they don't have the option of having that answered because they're gone. Their parent, their loved one, they're gone. They cannot ever get that question answered. And I just think, I'm a big believer in talking about it. I always encourage my clients to talk about it. I appreciate a lot of private. I get that too. I respect that. But I just think, particularly for the ones that have a risky situation that could very well end up in a dispute, absolutely talk about it. Yes, it's awful. It's uncomfortable. It's the most horrible conversation you'll have. But believe me, it's better than the alternative. Really.
I always say that, and this is particularly when it comes to even just writing other wishes in your letter of wishes, that it's significantly easier to have a conversation while you're alive than when you're dead.
Yep. Yeah. And writing reasons isn't necessarily enough because it's one way. You need that two-way conversation to not only explain those reasons, but there might be a whole bunch of misunderstandings that have the opportunity to be clarified or fixed, and I just think that there's value in that at the very least. It might put Caite out of the job one day, but I have a feeling it might not at the same time. I'm sure it won't.
But I'm all for it. I'm all for it. I mean, I still get surprised at how appalled I can get on a weekly basis of the way that people behave to people who are supposed to be their loved ones. So gosh, even if it did me out of a job, I would be happy about that. I mean, I much prefer to see people doing the right thing. I'm pretty confident I'm not going to be out of a job because most of those people who won't have those conversations will never have those conversations. They haven't had them for the last 60, 70 years with family members. They're not going to start now. I think I'm pretty safe. But you know what? If it did, I think if a couple of people listening to this podcast change the conversation that they have with their clients in these situations, and one or two people a year have those extra conversations with people, and so a claim's not brought, then I'd be happy.
In terms of how you have that conversation, Michele and Caite, how do you think there's a structured way that you can do that? Like, do you engage as a facilitator, or is it just you need to go and sit down and talk to your child, or is there a way that you have found in your practice, in your experience, that works best? Or
I might weigh in first, if that's all right. Everyone's different, and I think you need to be flexible to address the kind of client that you have in front of you. Some of them are very private and don't talk that openly and easily about that sort of conversation. So I think that's something you need to be aware of right from the beginning and adjust accordingly. When you see someone shutting down about that conversation, you need to adjust the language that you might use. But I think in terms of structures, I think what I tend to find works best is absolutely critical. You have to build that rapport with the client before you have those really tough conversations about what they need to talk about. Because they're just not going to take it on. They're not going to take on board something that's very personal to them and some lawyers telling them how to talk about it. Like that can't go down well. But if it's someone that you've built that rapport and they appreciate that you're actually trying to help them do what you are doing in the most effective way. And that's not always the document you end up producing. That might be the entire experience with that lawyer. And I'll just say this, I know that a lot of this conversation, they take time. And that therefore means billable hours and it means cost, etc. I get that. And yes, some people, and this is that whole value versus, the value pricing kind of thing. You're offering value that not everyone can offer if you are going to sit there and spend the time to build the rapport and have those difficult conversations. that's the experience the client's walking away with in the back of their mind, and that will reflect in the costing. Yes, it costs more time, but I'm hoping that if you've built that relationship well enough with the client, that won't be an issue as much as if you were just, documenting something and off you go kind of thing. I think I might have digressed a little bit there. What was the question again?
I don't have a lot to add there, Carrie, just because I don't do that front end work really, but I see a little bit, and I think the people who work a lot in the collaborative space are
Yes, I was going to suggest
certainly
collaborative
encouraging that kind of collaborative approach, where you have, for example, somebody, and I think in rural succession it's a pretty big thing too. Although I think in
because
rural
there's
succession
multiple,
there's multiple
generations.
there's different
There's a
businesses,
lot to
there's
consider.
issues with high value assets, not much cash or not much other assets, that sort of thing. Transitions of businesses between generations and all that kind of thing.
And selling off assets in a dispute situation is not simple. Not at all in rural areas. I mean, for those that don't know, I'm in Emerald, Central Queensland. It is not easy to shift assets out of and sell them. If you've got a dispute,
we had a really good live on farming families and estate planning for them with a lot of these different topics, which I encourage anybody that's listening and is giving advice to farming families to go back and watch that, because you're absolutely right. There are so many moving parts, and they usually are families, and there's lots of different things going on that you need everybody involved in.
Yeah, absolutely. Even Gympie had a matter as dispute matter, a de facto dispute years ago, and that it took 2 years to get to mediation. And it was a property in Gympie that was the really difficult sticking point. There was not a lot of liquid assets at all. It was a property, and you just couldn't shift it. And so that conversation is even more important in situations like that, where there is just difficult assets. There's family inheritance, like, the multi-generational aspect, whether it's rural or otherwise. They're such important things. Collaborative practice, big fan of that. I'm collaboratively trained myself, and you can do very much the pre-death and post-death collaborative practice. And the pre-death is exactly what you mentioned before, Carrie, about a facilitator to talk about the issues, getting to the heart of the issues, so people have a safe environment to work through the reasons that they want to leave a will certain way, but having the two-way conversation, because there's another conversation just in the comments below about anyone using recordings to explain their position to potential beneficiaries. I get that. However, the only issue I would see with that kind of approach would be that it's one way still. It needs to be two ways to have it valuable for anyone, in my opinion.
That's really,
I agree with that.
I think that it's because it is a story of two sides, and I always say with
or three or four,
well, true, but in terms of between the person that's got the issue and the person that is the center of the issue, so to speak, is that the truth is always somewhere between the two stories, and we don't really know on that spectrum where the actual truth is. It could be all the way up here, it could be all the way down there.
Exactly.
And then without having that other person involved, it's very difficult and having that knowledge. So I'm just conscious of time, ladies. So I just wanted to say thank you so much for joining us today and for sharing. I certainly, Kate, I'm going to go and have a heart attack about what you said about it only ever feeding the defense, the applicant rather than the defense. But as Michele,
on that topic, though, Carrie, we did mention that on the Airwaves podcast that we did on that topic, and that was that to and fro for that very reason. Litigator and planner.
And of course, that is not, and it's also that's not the solicitor's fault. It's not anybody's fault that happens. It's just what the facts
circumstances are. Remembering they had the issue when they walked into your office. Okay, that existed before.
I think that as you said, it doesn't necessarily change the fact that the client might want to document their intentions or their wishes, or just do that brain spew onto paper, so to speak. But it's certainly given us a lot of thought to how to document, why to document, and particularly around things like where you keep the records. If anybody has any questions, please feel free to bring them to the hot seat, or always send us a question. Michele and Caite have a wonderful podcast called The Airwaves, available on a series of different facilities. I listen to it on Apple Podcasts, but I think it's also on Spotify as well.
And Spotify and Google, and you can listen direct on our website, which is theairwaves.com. So a few ways.
So encouraging anybody that has their inner estate planning nerd ready to fly free to get a hold of that. And thanks again so much, Michele and Caite. We look forward to seeing everybody again next month.
Thanks, Carrie. Thanks, everyone. Have a great day.
Thank you. Bye.